All right, you guys, we're going to switch over to this real quick. Okay, somebody's being accused of influencing a witness. All right, here we go. Day 88, a young thug. That's kind of funny if you know, 14. We'll just leave it at that. We'll leave it at that, guys. So let's go here. Let's see what happens. But thank you, Darcy, for the super chat.
All right, do we have everybody with here? Sergeant Ingram?
Yes, sir. Everybody's present.
Okay, Mr. Steele, would you take the podium, please, sir? All right.
Okay, guys, this is a contempt hearing.
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, that's
What? Oh, shit. Oh, wow. Wow. Apparently, he got information about he got info. This is Young Thug's lawyer, Brian Steele. This is Young Thug's lawyer right up there right now. It sounds like he got information privilege like from the judge's chambers.
That's why I raise it. It is that serious that we should have been there and it shouldn't happen.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
No. That is a very valid issue. The prosecution and a witness met with the judge. Oh, he has every right to know what that conversation was about.
How did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot. You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with
the
contempt.
privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an
may be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not.
Sir,
gonna
I don't
breach that
want to. I don't
contract.
want to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who
cannot
raised it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, you listen and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From
that
whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk.
well then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So
But you're assuming something because I told you already.
well, then other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have
What I got this information.
I'm not going to have any further conversation
Well,
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your
I
motion. I'm going to deny your motion.
I understand.
This is a fucking G move, chat. This is a G move. Fucking G move right there, chat. That is a low-key flex. No, that's like dragging your dick in the dirt energy. Big dick energy right there. Wow. Fucking homie.
That you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief. And I'd like to.
You admit to having the ex parte conversation with the witness? You stupid fuck. Why would you? Well, I mean, I'm glad you admitted to it. But yes, mistrial. What? None of the defense knew about it. Ooh. Ooh. Wow. Look at this. He's getting cuffed up, chat.
Have that all in the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day.
But why?
Okay,
Why
that's for
did we
another day.
exclude in the first place? I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that the one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, John.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got,
because unless you're sitting there, you're eavesdropping. So you can't use something. Or
maybe he's really freaking smart too. I don't know, but you have no idea. You need to go do your mole hunt, Glanville.
Ordinarily, that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or the a party didn't give you the information.
Born.
So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we?
That needs to be told.
Correct.
But
right now, we don't know
Mr. Steele,
why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Lowe.
Oh, I'm sure she's gonna be all indignant now. This is so mean, Judge.
Defense
man
I
bad.
said this previously,
Yes, sir.
but we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right. Yes,
Wait.
ma'am.
Your Honor,
Wait, he just threatened him with jail, and he didn't jail him. He just threatened him with jail, and he didn't jail the guy. He's like, I'm gonna cuff you up, and then he didn't cuff him up. What the fuck? What? Like he missed. He threatened to cuff him up. The bailiff walked over, and now the bailiff walked away. Glanville's all bark, man. What a G. What a G.
am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants. We cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am
including
not
the state.
comfortable stating publicly at this time, but that
You don't feel comfortable?
would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the
There's
information.
nothing to strike. The jury's not around. He made his statements. If it's stricken from the record, like, you're going to erase that? That don't work that way.
That was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 standing there. 1.6 in no way shields Mr. Steele's answer that the court requested.
We're going to have to cover this Thursday,
Rule
guys.
1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Now, here's the difference, guys. This is Rule 1.6 for the Georgia Rules of Professional Conduct, okay? So he said comment 5. The principle of confidentiality is given effect to 2 related bodies of law. So right here, you guys should be able to read that. Okay. So we get down to the rule of attorney-client privilege and attorney-client confidentiality applies to situations other than those where the evidence is sought from the lawyer through the compulsion of law. 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required to by the Georgia Rules of Professional Conduct or other law. The requirement to maintain confidentiality of information gained in a professional relationship applies to government lawyers who may disagree with the client's policy goals. Steele got it on the money. Steele's got it right, chat. Steele's got it right. Man, Steele's got ice water in his veins. Freaking OG move right here.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay. Yeah, he does. But
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but
Damn! Wow, this dude's like, yeah, Adams. My God, he just stood there and he's like, "Listen, if you're going after my homie, you better come after me." Like, these guys are straight up savages, chat. Straight up savage. That's a savage move. Knowing your buddy's gonna get lit up, and you're like, fuck it. You know what, Judge? You know what? I'm gonna lace up my boots too. I brought a toothbrush. You're gonna have to take me down as well. Man, that's some baller shit. This is OG stuff right here, chat. Fuck, if I am ever in that situation, I hope I fucking man up too. I hope I man the fuck up. I mean, really, I hope at that point I fucking step up like that. I hope I can step up like that.
I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not.
Now, this is interesting. He needs to be Now, I think they were smart enough they could use him and say, I don't know what you guys did. Now I have the right to know what you did. Now he's able to say, I got clean hands, Judge. So you tell me what the fuck you done.
Not a false accuser. Okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations.
We'll get to
But I
this
do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the same.
All right.
Good afternoon, Your Honor. Carson Matthews, on behalf of Mr. Mark.
all these guys are stepping
Okay.
up.
We are also adopting all departments.
Gangsters,
All right,
one and
sir.
all.
Still by Attorney Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also we were here at the appropriate time. And when the court did come out, we were not made aware that there had been an communication that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Gardner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
He's really going to do it?
Yeah, we're going to continue. I'm not calling nothing.
I'm not going to participate in the trial without Mr. Steele and
You don't have that luxury at this point in time, sir. You don't. You don't.
This guy here, I don't know his name, but he is awesome. Brian Steele's got a set of balls, but this guy he's standing up in front of the machine gun and screaming, "Hey, shoot at me too." That I think is a bigger set. That's a big set of balls too. He says, "I'm not going if you take him away." Like he's like, it's like backdraft. You go, like, you know, you go, we go type of moment. You know, if you go, I go. And I don't blame him, but it's funny. He's like, I had the same information too, and the judge is like, I don't fucking care about you, which I think shows bias. But holy shit.
You don't have that luxury. You don't have that luxury at this point in time. You don't. Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Respectfully, I will not. I cannot. Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are.
That is not extortion. That is not extortion. Holding you out for what you've done that's violated the rules is not extortion.
What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. Sir, that's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only. Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Now he's doing it the right way. When they say cuff up, it's cuff up time, chat. There ain't no time to fight. You take it like. You take this is a great example of it. You take your fucking pinch like a man. And Brian Steele's taking his pinch like a man. Fucking baller. Fucking baller. We'll get to your guys' questions. We'll get to your questions.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
Wow, chat.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Fucking A. Like a champ, chat.
We're going to be in recess for the next 5 minutes.
This is an OG call. Who lad? Who lad? All right, we're 17 minutes behind. We're going to catch back up. Here we go.
Is Mr. Adams in the hallway over there? Could you get him, please?
Chat, this is insane. This is insane. It never goes this far. It never goes this far. Wow. Man, like I said, when it comes my turn to do that, you know, welcome back to the page of history. You got to be that dude, man. You got to be that dude.
Wait.
Tell Mr. Adams to come inside and put some stuff on the record, please.
Also, if you guys were not aware, he is Brigadier General Glanville in the U.S. Army Reserve. He is a JAG officer, Judge Advocate General officer. So what are we doing? Come on now. Let's get to it. You know, Judge Glanville, I'm putting together this thumbnail for you, buddy. You better not leave me. You better not blue ball us. Although Brian Steele's playing it right, man. You know, that, as we talked about. So if you guys are not aware, in the Young Thug trial, and we'll start off with that, because Young Thug's got his RICO trial going, and we're going to mute it for a second. In the Young Thug trial, one of the witnesses refused to testify on Friday. He came in today and agreed to testify. At some point, Young Thug's attorney, Brian Steele, learned of information that the judge, the district attorney, and this witness all talked without anybody else present. That's an ex parte communication. What happened from there? At that point, Brian Steele learned of the conversation. He's Young Thug's actual attorney. Now, it doesn't, you know, the witness was not sympathetic to the state, and he'd already been sworn in. It's pretty clear how he got the information this meeting happened was the witness told Brian Steele, the word got to Brian Steele from this witness, hey, the judge basically told me to go testify. So real quick, we're going to pause. So with all that being said, the judge's first reaction to getting caught having an ex parte communication wasn't, you're right, that was wrong. It was, who told you about it? He was more mad at the fact he got outed than what he did. Brian Steele, under the threat of contempt, refused to tell him. And why? Because of the rules of professional conduct in Georgia, it's specifically Rule 1.6, Comment 5, this one right here. It says, you know, this applies to not matters implicated in confidence by the client, but also information gained in the relationship, whatever its source. So Brian Steele is saying, I have no ability to tell you what are the rules of professional conduct. The Rule 1.6 is the one you take all the way. You don't ever breach it. And there may be times where you have to, but this isn't one of them. And the judge said, tell me you're going to jail. And Brian Steele says, fuck you. I want a mistrial. The judge said, fuck you. We're not doing that. Well, Brian Steele said, guess what? He's like, fuck you. I'm not. Fuck you. And he pulled a Nick Ricada, except this is justified. Fuck you. I'm not going to do what you tell me. And he did it like a fucking G. He asked for a mistrial. All defense counsel asked for a mistrial. And it's funny because Keith Adams, Young Thug has two attorneys, Keith Adams and Brian Steele. Keith Adams stood up and said, Judge, I have that same information too. So therefore, you'd better hold me in contempt as well. That guy stood up in the line of fire and was standing there screaming, I dare you to shoot at me. And Judge Glanville said, no, I'm not shooting at you. Only Brian Steele. After that all happened, after the state got to have their say, Brian Steele once again asked for a mistrial. Judge said, are you going to tell me? And he said, nope. And the judge just had him escorted in the back. That's where we are. That's where we are, guys. And that's why we're doing this right now instead of Karen Reed. Holy Jesus Christ on a cracker. That was intense. That was intense. The judge got felted? Yeah. Brian Steele says, I got more push and you got time. And Brian Steele fucking cuffed up and went in the back. It's an OG call, man. That's an OG call. Like I said, I hope I'm in that position. I never want to be in that position, but if I'm ever in that position, I hope I fucking do it just like that. All right, Judge, I'll see you in the back. Now, I might say I'm a little fat myself. I'll be like, do I get a lunch tray? Do I get a dinner tray? The accusation is the judge tampered with the witness. They had an ex parte communication. And this was after the guy was already sworn in to testify because he was sworn in on Friday and refused to testify. You can't do that with a sworn witness. And nobody in the defense knew about it. Have you ever been cuffed before? Like when I got a DUI, I got cuffed. But no, not in court. No. I generally play it by the rules. But I've never been in a situation like that. The judge has fucked this case up. Because he admits he did it. He admits he did it. This trial is done. That is reversible error. It is structural error. This trial is completely fucked now. This judge fucked away 88 days of trial.
All right. Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams. And I don't doubt that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of all these. I'm not asking for any other or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect this court. I respect this court has to do whatever it is appropriate. But I would ask that the court also respect my representation as Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a free trial. And we believe that that's the position we're in. And I would respectfully decline the court's order to continue forward.
Your Honor, may I address the court? Thank you. Your Honor, there are two things at issue here. And one of them, Your Honor, is that...
Can I ask of the court how it is that the state has any position in this particular conversation between the court and myself?
Before we recess, Ms. Love said that she was going to research this ethical issue because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir. Okay?
Thank you, Your Honor. We believe
Research in the ethical issue. You're not allowed to have ex parte communications. There is no research into this. There is no research. You can't do this. This is not acceptable. It's not. You can't do this. There is no research into this. You're not going to find somewhere that says it's okay for you guys to have an ex parte communication with a sworn witness without notifying defense counsel. No. And the fact they found out, that doesn't excuse what you've done. You could find out on later words, but you need to address the fact you introduced error into this trial for the millionth time. No. This is insane.
that there are two matters at issue here. One, obviously, is Mr. Williams' right to counsel of his choice during the trial of the case.
Yes.
We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not.
They know this is bad. They know this is really, 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 really bad. They're like, Judge, what? They're like, Judge, whoa. They're like, pull the bullets out of the gun, Judge. No. They're like, no, don't. They're screaming at him like, Hank, no, Hank, don't do it, Hank. They're screaming at him, don't do it. They're trying to they are trying to pull bullets out of a dead body right now. And I don't think they realize he's dead.
Affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that so far this issue alone has needlessly delayed the trial of the case. And we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish.
Bullshit. How do we know that? Oh, we promised we didn't do nothing wrong. Yeah, that ain't how this works. That ain't how this works now. The fact you get caught doesn't mean you get to come back and say, well, we didn't do nothing. No, that's not how this works. Especially not with you guys.
The matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing.
That's not how this works. You don't get to say that.
And the state said, Your Honor, we're asking if they don't comply, that the court hold that person in contempt. That was a civil contempt matter.
You don't get to do that.
Nothing substantive was discussed.
You don't get to do that.
Everything was recorded, and
sorry,
the
baby girl,
representations made, at least by persons who were present,
according to you,
the state is that
Oh, baby girl. That,
when questioned or queried about it, is that that person was told or asked whether things occurred, and that person relayed that no substantive communication took place during that meeting.
you don't get to decide
So
this.
that is the second matter.
You don't get to
And
decide that.
First and foremost, we just ask that the court again allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right. That's fair enough.
Thank you.
Okay.
Your Honor,
Mr. Sharp?
the ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the
Your Honor, can I just-
Mr. Sharp, here's the challenge. You got the information in a way that was not lawful to begin with. Sir, that doesn't alleviate the information or make it less valid or invalid.
How is it unlawful? How is it unlawful? They gain knowledge through unethical conduct. It's not unlawful. For you to sit here and say it's unlawful, your conduct is unethical. You're not entitled to hide your unethical conduct.
So, because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's great.
And like I said,
This is what I know.
if and when the case gets reviewed, an appellate court will make those decisions. But at this point,
My client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
okay, and that's your argument, sir. That's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not sun. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay. Well,
So
at this point, I'm, like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. I'm not saying that you may or may not get that information, but at this point, there was nothing that was improper about and the ex parte conversations. The court's
All right.
more concerned about is the disclosure.
You don't get to say that.
So, and
I understand the court's concern, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
okay. All right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
And Judge, the only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present, his lawyer stated to Your Honor that he had spoken to his witness, his client. And
Hold on,
he
guys.
stated that the witness indicated
Right
that
now,
on
buddy.
Monday, he will
You wanna
also
airdrop
be
in.
saying that he will plead the fifth. And then, Your Honor,
There you go,
was a
Steve.
2-3
Coming
hour
hot, man.
span
Cleared
this
hot.
morning, and then he comes on and he says,
That's what you
I'm
are,
gonna
man.
testify.
You're cleared hot.
That's why I believe in the application of Huey that the transcript is important.
Okay. Thank you, sir. All right. Let's get Mr. Steele out, please. You can tell him to put his tie back on.
Steve, hi.
Boy, did I come in at the right time.
Wow. Okay, guys. And guys, the extraordinary and well-esteemed Steve Gosney, a attorney out of the state of Florida, actually been both sides of the fence, but as a prosecutor and public defender, and a guy with a lot of insight and input I value a lot. Thanks for being here, Steve.
Well, thanks. I saw your screenshot and I was like, what? Who's being held in contempt? And then lay it on me.
Okay, so here's what happened. So Young Thug, he's got his trial going, right? Okay, so Young Thug's got two attorneys, Brian Steele and another guy, Keith Adams. As part of this trial, obviously it's gangsters and guys in a gang. Well, one of the guys that was called in to testify on Friday was one of the gang members. And he's like, nah, I ain't doing that. And they immunized him. And he said, yeah, I'm still not testifying. So obviously, you know the answer to that after you've been given immunity. You go sit in the back. So he sat for the weekend. They brought him out this morning and he decided he was going to testify. Well, around the lunch hour, Young Thug's attorney, Brian Steele, came out and said, hey, Judge, I know y'all had an ex parte communication with this witness who's already been sworn under oath because he came in and sat down and said, I'm not talking. And they put him in the back. Now, that's already a problem because once the witness is sworn, nobody's allowed to talk to him.
Even his attorney.
Yeah.
So once, and let's be clear what we're talking about. Somebody swears in, they're sworn, they're put on the witness stand.
Yeah.
The person can say, hey, can I take a break and talk to my attorney about the answer to that question? The answer to that is no.
No.
So what's happened is he is sworn in, he takes the fifth, and then the attorney, they give him immunity. Now there's some questions about federal stuff.
And there's an issue with that.
There's an issue with that, but let's assume that his immunity is good.
Yeah.
Then the judge talked to the witness.
Yes. And the judge's first answer the judge's first response to that was, how did you know?
Right. How did you find that out?
How did you figure it out? Now, I think it's very likely the answer is the witness is very sympathetic to Young Thug, and through either his counsel, which, that guy's playing with fire if he did that, but somebody in that guy's camp reached out to Young Thug's people and said, by the way, this happened this morning.
Well, there should be there's so many ways to go with this, but the first thing I would do as a defense counsel would be file an interlocutory appeal, demanding a disqualification of that judge and a mistrial based on the allegation of contact. Now, you may need sworn testimony for that, so the source of that information may come out.
Yeah, but you don't need it though, because the state already explained what it was about. The state admits it happened.
Okay, well, the state admits it has, so that the state's that's mistrial. That should be a mistrial. That is
now the state's argument is because it was a civil contempt matter with this party that technically they're the only. Now I understand you're going to say this is a bullshit argument. I agree, but they made the argument just now. Well, because it was our contempt. We're the victim. It only concerns us.
No, because you don't know what's being. There's ex parte.
Well, yes. Oh, yeah. No, that's the counterpoint is we don't know what you guys said.
And the witness is sworn, and they're on the stand.
Yes. But their argument was that because that contempt was hurting us, we're the only victim. You guys really don't have standing. It didn't matter that you weren't there. And it's like, no, that's not how that works.
No, this is
the
terrible.
State admitted they just did that.
Yeah, it's terrible.
There's no need. There's no need to mess with the record because they just admitted they did it. And it's like, well, I would immediately ask for an interlocutory appeal. What jurisdiction is this? This is Fulton County, Georgia. Oh, wonderful. So this is Fannie Willis country. Yeah, and the funny thing is, I've been saying this for a while now. This is a preview for the Trump trial. It's probably going to go this good.
But the thing is I'm not following this at all because I know
Yeah.
Nick Starro is following it very closely.
It's a dumpster fire of a trial.
And I hear it's going to be like months and months and months and months. And whenever I hear a trial's going on months and months and months, there's something wrong with either the judge or the prosecutor or both.
Well, it's because it's a RICO case, and the problem is
what? I've tried RICO cases before.
Yes, and this is the problem. It's because these guys suck. But the other issue is in Georgia, the way RICO's set up. It's the same reason why Trump's being charged with it. RICO is if two people commit a crime. That's RICO. Not necessarily like an organized pattern of criminal activity, and you can organize a hierarchy and there's predicates. It's two people committing a crime. That's RICO.
What? No, that's not RICO. Not in Florida.
It is under their law.
Mm-hmm. How many defendants are there?
There were 19. Well, there were 23. 5 have pled out. There are 5 or 6 that went their own way, and this is like the remainder of the bunch, including Young Thug and all the bigger guys.
They shouldn't. I also really think the state gets a little overly aggressive by joining defendants. Yeah. There's so many problems with that.
Mm-hmm. Here's the problem too. We're 88 days in, and the case started in November.
It's ridiculous. The judge needs to. I mean, I went back because I saw your headline, and I went back and I watched the contempt proceeding.
Yeah,
and that was garbage. And I'll say that. Let's just talk about how the mechanism that works. There will be defense attorneys posting bond for him immediately. All right. So, he'll spend maybe a few hours going through the system.
He's coming back out because the judges. I don't know if you saw the part here where I was explaining. The state's they're like, wait, judge, he might actually have the right to counsel here.
Yes. Well, see, this is the thing. This is a denial of counsel. If you take his attorney out, you have a right to counsel. He's hired his attorney. Now you've taken that person out of the courtroom, and then you're going to conduct material proceedings without that guy's lawyer. Now you've just deprived him. The judge could get kicked off the bench for that. I've seen judges get kicked off the bench for that in Florida. See what this judge was at. The judge was out of line. I watched what he was doing. He just didn't like the defense attorney's accusation. Well, too bad.
Yeah, and like I said, I love his answer. The first answer was, "How did you figure that out?" Not
right.
Oh, you caught me.
No, and that's an admission of guilt. That judge should be out.
Oh yeah. Oh, he admitted it. He admitted to having the hearing too.
Huh?
He admitted to having it as well.
Yeah.
He 100% admitted to having it. And I'm like, well, there you go.
Well, they should move to disqualify the judge. They should they should interlocutory appeal, demanding mistrial, a lot of stuff now. And it's funny because it seems like the judge came back and let him back out. So he's seeing the denial of counsel problem, thankfully. Yeah. Maybe he's grown a brain.
Well,
but there is you remove the guy's trial counsel and then you say, now keep going. That the judge could lose his seat for that. In a functioning bar. I don't know if Georgia's bar is how good they are with that stuff, but
yeah, well, I think the funnier part was the state sitting up there like almost begging the judge, like, no, don't pull the bullets out of his body. Noticing they caused the problem here. And I just it's just something to see. I mean, he took off his side. It's like, fine, I'll go in the back. I know in Ohio, for example, if you remember the criminal defense bar, they have this thing called the strike force, and other states have it too, where there's attorneys who they get the call and their wheels up coming to help because it's hard to fight this from behind bars. Oh, now, some of you guys are wondering what's going to happen to him. So here's what's going to happen. The way contempt works, and some people were wondering, and we got a bunch of questions here. And once again, thank you to Darcy for telling me about this over an hour ago. You demand, Darcy. And Miko says it's an ex parte and one president is present, not the other. Yes, correct. That's the definition.
Well, ex parte means you're meeting with somebody without the knowledge of outside the courtroom. So they're meeting behind the curtain. And the defense attorney, so the judge and the prosecutor are meeting with a witness on the stand and without the defense attorney present.
None of the defense attorneys for the other 13 people either. Nobody
The
knew
judge
about it.
just disqualified himself. Maybe. I mean, this is I'm glad we have
Well-
cameras in the courtroom, but you don't know. I mean, it could keep rolling along. The appellate court could say no.
Well, this part here, I think Brian Steele is correct on, because this is the Georgia rules of professional conduct, and this is 1.6 comment 5. And I don't know about Florida's, but I've never had this conflict. I've never had this ethical issue before, but
I have.
well, I've kind of run into it, but nobody ever thought to ask me, like, how do I have the information I have? So
That to me is terrible. How did you
Yeah.
find? Like, no, I didn't do it. How did you find out?
Yeah, well, but I've had it where I can say things, and I'm like, nobody asked me a question. I'm just like, I'm not going to raise it. I'm not going to bring it up. That's their fault. But yes, it applies to matters in confidence by the client, but also information gained, whatever the source, because that's meant to help your client, guys. That's why he did that.
Well,
It's my job.
As from a defense attorney perspective, this type of action is a real badge of honor. And I will say that you went to war and you were ready to go to jail
Yes.
for your client.
A lot of
clients love
attorneys. I don't know if a lot of attorneys have backed down, but I don't know if there's a lot of attorneys who would have raised hell like he did, though.
Good for him.
Yeah.
You got to be.
Oh yeah, no.
do
Here, like that. Brian Steele's an accomplished attorney down in that area, but he got extra stripes today for that.
And the client, what I'm saying is,
Mhm.
it's good for business because clients want you to fight for them. And
Yes.
if you're not willing to go to the wall, if you're willing to get cowed by a judge and say, "Okay, John, or I'll just shut up and sit down," then you are not. That's what it takes. That's the balls it takes. And people like to diss us defense attorneys, but you got to be ready to go.
Yeah.
Right?
Yeah, and Squizgar says, how do they fit those balls behind the podium? I don't know. And EDW Raptor says, so is the judge and the prosecutor more or less committing a RICO violation themselves?
Yeah. No, not really. That I
No, but
understand.
they're doing highly sanctionable conduct, which they should be sanctioned for.
Both. Yeah. Well,
The prosecutor, too, because they know better as well.
do they?
Well, they were trying to make that argument of like, well, we're the victims in our contempt. It's like, it's not going to work.
There's no victims here. That's not the question.
Yeah. Well, no, that's how they justify. Well, the state came out and justified why they had the contempt or why they had the ex parte. Like, you guys didn't have to know because it didn't concern you.
Yeah, trust me.
And it's like, no, the confrontation of a witness does concern us. Bella's bringing up an interesting issue. Did the witness set this up? Oh my God. That. Wow. These motherfuckers are smart. Yes, but I guess like these guys are crooks. Could they be this bright? Maybe. That's fucking brilliant. That's brilliant. I could see that. That's some Lincoln lawyer shit. Yeah, that's also you could lose your law license shit. Oof. That's some Musashi, like killing somebody with a wood sword, or even just like Fushida said before they went to Midway. One touch of an armored sleeve. That's the lawyer could have set it up. That what though? Here's a problem though. That's a dangerous gambit as an attorney. Here's what I wouldn't. If that was proposed to me, I would not set that up. Now, if my clients did all that and other people are doing shit, what do I know? But that is a dangerous game as an attorney to play. That's a dangerous game. Yeah, Bella said this here. Mistrial with prejudice. I think so because it's judicial and prosecutorial misconduct.
Well, let's talk about that because it has to be prosecutorial misconduct.
Oh, I think it's both.
Yeah, it could, it's possible. It's possible. That's a very high bar to do. It's possible though, because the prosecutor was in on the conversation. Now, is that significant enough to bar a retrial? Because what we're talking about is double jeopardy.
Yes.
So if a mistrial is caused by the defense attorney, then they can retry it. But if the mistrial is caused by the state, then they've sworn the jury, and that means that jeopardy has attached. And the state does something sleazy to cause a mistrial, that can potentially result in a bar, and that would be immediately appealable because it would be. So let's say there was a mistrial granted based on prosecutorial misconduct.
Yes.
Then you would bring that immediately because that would mean double jeopardy would bar it. It would be constitutionally.
Yes. Oh, I agree. And the state would appeal it. But this is interesting here. Bella's saying it. Now, I know these guys are crooks, and they probably are savvy. But the idea is, did they set this up? Do you think the witness, the witness,
is pretty sophisticated to set up?
I mean, that's even sophisticated for attorneys to set this up.
Yeah, I doubt it.
But I mean, they could.
Why would the judge fall for it?
Glanville has made a lot of bad decisions in this trial so far.
Yeah.
He's done a lot of weird stuff. Oh, the court's back in. We can actually see what happens here. Because he brings Brian Steele back in. So let's see what happens.
Okay.
Sorry, Steve. Let's see what this is here.
Let's see if we hear any.
The continued representation of Mr. Williams is been brought to court suggestion that you be here until when we've at all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying that he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Ask a question.
Yes, sir.
Did the court
This is Brian Steele, by the way.
Yeah, I saw it. I replayed it.
order the transcript that we can see it and have a hearing and call witnesses?
No, I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that.
That's
I don't
error right
believe at this
there.
point in
That's
time,
error. It's in the
it is the
record.
court's understanding.
This is like
Something-
you're
there's
we're having
something
now
in the
error.
record that the defense attorney can't see.
Yeah, that like he's just said like no, I'm not going to give you the record.
But
That's
it's in the
error.
appellate court. I review records in the appellate court. There's something that's in the record that the court has been involved with that you can't see. I mean, what the hell is that?
Yeah, and I hate this mindset of, oh well, if I'm wrong, we'll fix it later. What, like 5 years from now?
Ugh, horrid.
Oh my God, this guy is, J-Rock, I know you're out there, buddy. I know you're my bro. You guys need to go talk to this guy because Glanville has lost his damn mind.
It sounds to me like incompetence.
I think this is an overwhelming trial. I'm sure it's fried his brain.
Well, yeah, it is too much. And he, like I said, he doesn't have his foundations of trial work. Probably. I don't know what this guy's background is.
He's a brigadier general in the JAG Corps.
Well, that could be.
So he has experience at doing like prosecuting and defending. I think he was a defense attorney prior. I think that he's just not used to being told no. And it's like you said, it's just like, well, rah, 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 rah. I just don't think he's prepared for that.
Well, he's over his head from in this day. Let's keep going here.
This is going to be one of these things at judge conferences. They're going to be playing this clip.
Ending of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed. But
no,
I'm not at this point in time going to release
they're both
any of the
bad.
transcript in terms of
In
what
fact,
may
ex
be
parte's worse.
disclosed or that was.
I mean, that's the thing.
He's doubling down on stupid.
Yeah, and that's the thing. Like, okay, somebody disclosed and snitched out you committing unethical conduct. That's actually acceptable. You're allowed to stop unethical conduct. If that's one of the ways I could break confidence is to prevent, fraud on the court. I have duties of candor. There are times where you can break confidence and you can't, if it's a breaking of the rules, like if I know somebody's breaking the rules, like you as an attorney, if you and me were like working in the same office and I know you were breaching the rules, I have a duty to report you.
Yeah, tell me about it. I got fired for that.
Yeah, but you know what I mean. But yeah,
I do. Believe me, I do. I know it very painfully.
This idea of him saying, "Oh, the disclosure's the problem." No, it's not.
No, it is not.
The disclosure. You got caught with your pants down. That's tough shit. You broke the rules, and you don't get the right to investigate that. You should have acknowledged you're right. These are wrong. I violated the rules of professional conduct. I violated judicial canons. I need to recuse myself and, declare a mistrial.
Well, but he can't make that judgment. He's trying to make a judgment on something that he's basically intertwined with.
Yes. Yeah, he needs to say, I'm wrong. I need to be out.
He needs to disqualify himself immediately.
Yeah.
And then the defense attorney, I would expect, should be asking him to disqualify himself.
I'm assuming that's coming.
He didn't double down on stupid. He went all in.
Yes, he did. He just pushed all them chips in the middle.
But this is bad black robe syndrome where they think that they are the law and anything they say that comes out of their mouth is pure and the God's gift to the law. They speak the law.
Nobody's up on the stand right now, guys. Here we go. Let's hear about the rest of this.
Said in Chambers ex parte at this point.
Well,
Notice he admits to it.
Told based upon information and belief that it would affect this witness's testimony in front of the jury because I was told based upon information and belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know.
I don't know. He's lying right now.
Oh my God. How do you not know if you were there?
Lying. He just committed a lie right there. I don't know. No, yes or no, that was said. Or he could say, I'm not going to discuss it. For him to say, I don't know. You're now denying what you said on the record. Oh my God, this guy's he just talked himself into a hole. Wow. Chat, like, I'm not joking. This is like...
Yeah, I don't know what to do about these crazy jurisdictions like Fulton County and Manhattan DA, that where everything is corrupt from top to bottom.
Am I wrong?
What?
Am I wrong in that thought? Where the guy just said, right. My understanding is it was relayed to him, depending on how well he testifies, he goes home. And this judge is saying, I don't know. It's like...
He is not listening to this defense attorney.
Yeah.
And I get it being, some judges are state favors and they're biased towards the state. I get it. But this is beyond that. At some point, you got to listen to what they're saying. And what he is saying is incredibly dangerous for the preservation of his law license, his judicial seat, and this trial, not to mention this trial.
Yes. You ever want to see a man play soccer in a minefield? Here you go.
Let's keep going. This is interesting.
Yeah.
Who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing with the court as a witness, with the DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point.
You're wrong, buddy.
Because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So I mean,
who's privileged?
but that's beside the
There's no
point at this point in time. We're not going to argue about that.
There's no privilege there.
Privilege? What privilege? The judge doesn't have a privilege,
Yeah,
and the prosecutor doesn't have a
Doesn't have a
privilege.
privilege, and the witness with his attorney doesn't have a privilege because there were multiple parties in the room.
There
So
is
there's no attorney-client privilege there.
Horrible.
He's
And then
just throwing shit out now. He doesn't know what to do.
It's funny, the same trial I was talking about that was such pain for me, the judge did the same thing, talking about accusing the defense lawyers of being unethical when he was the one that was being unethical. I remember I had an appeal with that same judge, and he loved to talk about, because he was, I got stories. Let's keep going. This is fascinating.
I mean, he's already violating candor. Like,
This
the
is
judge
terrible.
has candor before his own tribunal chat.
Terrible.
This is...
I wonder
Right now, I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How can something, I'm not trying to be obstruction, but how can something be attorney-client privilege if it happens before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't.
I'm trying to get out.
Well, that's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you can't, and then you turn around and you say, well, I did something. The court.
No, he's entitled to that information. How? You are not the one who decides privilege here.
Horrible.
In this matter.
Judge is a
You're not
witness.
entitled to have it. Says who?
The judge is a witness. What
Yeah.
the hell is a judge doing
You're not a
meeting with
party
a
to
witness
this.
who's on the stand outside the presence? I've never seen that,
This is
except in proceedings where the judge is losing their seat. Have you
Yeah.
ever seen a judge meet ex parte with a witness on the stand, with excluding the attorney?
No, I've never. I don't think I've ever heard of this because it's kind of like one of those deals where it's like,
It's obvious. You
well,
don't
yeah, but you like if you presented this hypothetical in class, your ethics teacher would have said like, well, no, because that would be completely stupid.
Yeah, I mean, it's
Like
and then
nobody's that dumb.
And then he's whacking on him, saying that there's some attorney-client privilege here. There is no attorney-client privilege is between the client and the attorney. Okay,
Yeah.
that's the attorney-client privilege. If a third
Yeah.
party comes in and
It's
listens
gone.
in on that conversation, attorney-client privilege is broken.
And they
In
know
this
it's
case,
that, and they know that party's there,
so we have a judge and a DA that breaks any conversation.
and they know they're on the record too.
Yes, tyranny.
You know, I kind of get the feeling, I'm thinking about this, Steve. I wonder if this lawyer who was the stand-in for this guy on the stand, do you think he's got some issues too that he didn't report this?
I don't know. It's hard to sense.
It's
But I know the judge has a problem right here.
well, I know he's got problems, but God, if I'm this lawyer, I mean, God, a lot of people better be clenching their butt cheeks right now. This is making my feet sweat a little. Like I'm getting nervous listening to this.
It's there's a lot of judicial power sitting on that bench.
Yeah.
And it's powerful and it's dangerous. This is where government, the state, is dangerous
Yes.
because you get
It's
morons.
unmoored power right now.
Yes, power, and they're like judges with their look at this judge in Manhattan. Same thing, they think they can wield the sword of
Yes.
the state for their own personal benefit.
Yes. Well, I'd argue the ADA's and got some issues too, but right now, Judge Glanville just called all the thunder down on himself. But let's keep going.
Georgia Barr is who's the operative
Yeah.
here.
Well,
I
the
don't know.
Georgia Judicial Review people too.
Yeah.
There's going to be a lot of people asking questions. Whew.
Did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of the trial.
It's not, well,
Has a right to be at, and I'd like to exercise. Understanding what.
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what. You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it that where I'm kind of at a disadvantage at this point in time. So, because I didn't invite you into that particular proceeding, and I don't think you had the right to be there.
Well, all I know is what I told you, and there's more.
Okay. Well,
there's a witness testifying who met with the court and the DAs. That doesn't concern us,
Your Honor,
meaning the defense.
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you. So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in order?
In terms of what, sir?
I suppose contempt.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or whenever.
I think this is more civil contempt than criminal contempt.
This is ridiculous. This judge is out of his mind.
Yeah.
The judge is asking to get removed from the bench. This is
Well, I think the Court of Appeals is going to step in and take him up
immediately. I'd be filing that interlocutory appeal as we speak.
And that's the thing. And I tried to explain this earlier. When that happens, and a contempt issue happens, even if it was just a random Yahoo getting contempt, the Court of Appeals for that area is going to take it right away.
Yeah,
there's not going to be a scheduled briefing out. They're going to look at this and say, is this legit or not? And if this happened at 9 o'clock in the morning, they could have an answer by 3 in the afternoon.
Yes, and contempt hearings are appealable, and it's called an emergency writ of habeas corpus.
Yes.
So you put it as an emergency, and I've done that occasionally in this type situation where something is. I've never had a contempt hearing of a public defender that I've done, but I've had emergency petitions.
This actually is criminal contempt because you did it in front of the judge. So yeah, this would be criminal contempt in that regard. I was just reading.
And I will say also that I had a judge, Judge Attic, who I loved, who was my first judge. She was county court judge, and she never once held anybody ever in contempt, I don't think, for her entire career, because she had a lot of other tools for dealing with attorneys. There's a million steps you do before you get to that. That is a very big hammer that you're wielding, and you better damn well be sure.
It's a nuclear weapon.
And you're doing that on the defense attorney in the middle of trial? And he hasn't been contemptuous. He hasn't said anything. He's speaking in defense of his client, laying out a record for his client. What's the big hurry? You can do on day 88.
Yeah, and here's the thing: if the Court of Appeals overturns it and says release him immediately, you've just nuked the case.
It's a disaster.
Even if they uphold it, it's still going to be a massive issue. But yeah, let's see what they keep going.
Steele is not going to give in. He's got balls of steel, and
I love that. Is it written in an order? I'm not writing an order. Like, no, you have to do it. You have to do a journal entry. You can't do this off the clock.
Yeah, we just don't deal with a lot of criminal contempt against attorneys. I mean, it's just very, very rare. And to see it in a high-profile case in a courtroom on a murder charge, and
let's see what happens here. Let's keep going.
Have we finished? If you don't tell me what that is, tell me who that is. This is criminal contempt. I have asked you a question related to these particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important. It is important.
Okay. All right. So you got to think about it. All right.
Can I just, last thing, going forward is over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay?
And
All right.
on behalf of Mr. Stillwell, I'm going to review
Our Brady demand for any Brady material
Yes, sir.
that came out from any conversations with Mr. Copeland, between Mr. Copeland and the
Excellent.
district
Yes, sir.
attorney's office this morning.
All right. Summon our jurors, please.
what a disaster.
Well, he did. So, guys, because the prosecutor spoke to this guy, they have the right to demand all the Brady material from that.
That's right.
And the judges basically told them to go fuck themselves.
Unbelievable. And that's federal.
Yeah, that's Brady v. Maryland, guys. Brady v. Maryland, Giglio, Castigar, Bagley, all of them.
Unbelievable. Well, now they're going to put the guy on the stand with the defense attorney not knowing what was discussed between the prosecutor and the judge, and the guy's now on the stand. He's going to have to cross him without that information.
Well, I think. Well, at this point, I would start asking on cross. And if I was one of the other attorneys, if they have a hair on their ass, they would immediately go into.
Yeah. What was said?
What did you guys talk about this morning?
Yeah, exactly. Who was there?
Yes. What did you guys say?
What exactly was said? No, I absolutely, I'd be all over.
I guarantee you, he'd threaten them with contempt, but I'd be like, I guess we'll share a cell.
Exactly. I mean, this is.
Although at this point, because these guys have basically their practices are getting ruined because they've been spending so much time here in court with this. I almost I think I might say at some point, just for the YouTube clicks, if I was one of these guys, being a big guy myself, I'm like, will I at least will I get a dinner tray? Like, am I going to be jailed in time for dinner? Or am I going to have to sit all night? But no, the attorneys in that area are already the moment this happened, there are attorneys in that town making phone calls and organizing a defense. Like, that stuff is already moving, and he doesn't. There's a whirlwind brewing, and he doesn't know it.
Yeah, this is not what you do as a judge.
Yeah,
and there's a time for contempt on defense attorneys. But when you've got quality defense attorneys who are making legal arguments, they're not being condemned, they're bringing up legal issues in defense of their client.
Yes. And here's the other issue. This is the witness. They brought him in this time in his jail uniform.
They're bringing the witness in now.
Yes, in his jail uniform.
Doesn't judge have to approve interlocutory appeal? No.
Some questions, yes.
Well, not this.
If it's a final appealable order, no. And holding somebody in contempt is a final appealable order.
Yeah.
There are some orders you don't have to.
I think I'm surprised one of these defense attorneys isn't moving to disqualify the judge at this point.
I don't know either. I mean, all those guys sitting like a bump on a log. Normally when someone else is getting killed, you just sit there and shut up and mind your own business. But
yeah, but this is one where you line up and say,
it's all team effort. Yeah.
Yeah.
Judge, you should be disqualified. We'd ask you to recuse yourself now.
As I've gotten older, I've learned to be a lot quicker on the trigger on judicial disqualification, because when you're young, you're like, oh my God, this judge, I don't want to say something to offend him. But as you get older, you're like, wait a second, you need to disqualify yourself right now.
And I mean, if not now, when?
Right, exactly. Yeah. Exactly. See, they're being potentially criminal, Sean, man. You're the man. You know what you're talking about. You've been there, right? You know what this is about.
Yeah, this isn't it. I mean, Steve, you ever play the game Soul Calibur?
No.
Okay. Well, it's like when you fire up the game, it's an older game, and it's like, welcome back to the stage of history. It's like, dude, you are out there. This is what the world's gonna like. These other attorneys, like this, you're on TV, man. Like you're out there in the Super Bowl. Like, are you gonna stand up and throw down?
Right. That's right.
And like now I saw a couple of attorneys who are gunslingers and a couple who are bumps on a log, and it's like, well, I know who the gunslingers are.
No, I love that. I love this guy Steele.
Steele, Keith Adams, the other guy, the bald guy in the back. Like those three dudes are they're G's.
And see the thing, a good judge will thank, and a good prosecutor will thank the Lord for a great defense attorney.
Yeah.
But instead they get offended because they're objecting.
Yes. Well, it's because I say it all the time. Like when I'm in a trial, like the closing arguments, if I hear and I immediately object, I don't, I've gotten to the point where like I don't wait for them to hear something. I just say the defense. You know what? And you're right. You have to just say I'm going to protect my guy the way I protect my guy. And the one thing I always try to make him say is, I don't want to ever hear my client's name out of your mouth. I don't want to hear the word defendant out of your mouth, generally speaking. You have to, like you said, you got to be quick on the trigger. Yeah. And it's better. You know what? If I accidentally shoot too soon, oh well. We could, then it gets fixed. Remember, harmless error.
Kind of tells you you're able to authorize you to do that.
Let's catch up here. So here we go.
Right, Mr. Copeland. Sir, over here. Over here. It's me. The state has filed an order of request asking that you be relieved of your custodial portion of this particular contempt on the condition that you just continue to come back and give your testimony, okay?
That's exactly what Brian Steele said was going to happen.
I will release you from the custodial portion as long as you come back tomorrow morning. Fair enough? If you're not willing to do that, I'm going to leave you where you are. So the choice is yours, sir. The state's asked me to sign the order saying, hey, if you'll come back tomorrow morning, all I want to know is if that's the case.
I'll be back.
All right. 9:30 tomorrow morning, okay?
All right.
All right. All right. We can let Mr. Copeland be released and processed. That order, I'll go ahead and sign it. And
such bullshit.
Make a copy of it as the next.
Steele confirmed they were telling the truth, that he knew what was going on there.
This evening, okay? All right.
This judge is in deep shit, and I don't think he understands that, or he's flailing.
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
Well, I didn't call them, but.
Okay, and that's.
Let me just finish.
Okay.
Because you said to me that you figured out somebody told me this information and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that will fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And they're
8H.
He's entitled to have counsel. You're accusing him of committing a crime.
Then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right, well, no, we'll let Ms. Merchant in. That's fine.
Ashley Merchant.
Yeah,
Ashley Merchant, baby. Let's go, chat. Let's go.
right. Ms. Merchant, good to see you as usual.
Some ass.
I have told your client, you represent Mr. Steele, is that correct?
Yes.
For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication.
Baby.
He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court and is very.
Once again, it's not what they did. It's about what you did. It doesn't matter where he learned it. All that matters is you fucked this up. You broke all the fucking rules. You got to fucking take it like a man and fucking bail. But guys, it's not only that he is a judge, but he's a general officer. He's a brigadier general in the Army Reserve. So he's definitely pompous as fuck. He's got that air of him. How dare you accuse me? He better be fucking scared. I don't think he realizes how fucked he is.
Since it was a ex parte communication, we won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Get him. Get him.
Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about.
Alleged conversation.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215,
215,
Georgia app,
Georgia app.
372.
Okay.
Also 215, Georgia app, 349.
Okay.
That's Adams and Hasty.
Baby girl came in off. She's just like, she fucking tooled up. Let's go, girlfriend. Ashley Merkin's coming for that ass. Every defensive.
Do you have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other.
Uh-oh. Oh, chat. He needs to back down. It's too late. It's too late. Nope. Judge can't just say never mind now. Nope.
I'm not the only one here.
Nope. Too late.
There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
Securitize my
And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be allowed
I
to.
don't want them in my jury box, okay? No.
I understand.
What a pussy. Pussy Glanville. Fucking pussy lipped.
May one additional attorney come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
He's allowed to have counsel. You can't deny it.
Yeah, I certainly may, sure.
Great. Alex
He has right to counsel.
Alex Susser. Thank you, Judge.
Now, guys, you're wondering, hold on.
Henry Adams,
Every defense bar has a strike
it has
force.
two issues. One is
And the strike force is basically a team of fucking attorneys. If shit goes down, they got your back. Shit like this happens, they will show up. They're all over the state, and they will rally and show up ASAP. They drop what they're doing and show up. And there's enough of them that that's what this does.
the motion for disqualification. Okay. And that's
Senga girl, you're right. Oh my God. This is fucking appropriate. It's raining fucking sharks right now. It's
and I
raining
think
sharks.
the judge went ahead and did some other things that caused there to be that issue presented. So I don't think, Adam, I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna
Yes.
look at the other case just a second.
And there's several others when you're ready.
Okay, J-Rock. Okay. Okay. Hobby saying, could the judge do this? Isn't this misconduct? Yes. This is misconduct of the highest order. Misconduct of the highest order. He might lose his seat for this. This is really fucking bad. Like, this is bad. This is bad. And there's no backing out now, chat. The judge is stuck. He's already fucking fired a cruise missile. It's too late to say it was a practice or say, oops. Like, he's committed. He's fully committed the moment he went down this road.
Hasty's conduct didn't rise to a level in this system warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
so those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also
You said 279 Georgia what? I'm sorry?
Georgia 13.
Georgia 13?
It's 2005 case,
All right.
and it defines direct contempt and explains that it must actually
Hi, J-Rock.
interfere with the proceedings to be direct. There's also a couple other cases on that.
I'll open your present tonight.
See, but you all are covering under, let me see.
I'm sorry, Judge?
Hold on. Just a second. Pardon me.
Yep, guys, this Ashley Merkant. She is from the Trump case, and she's the president of the Georgia Association of Criminal Defense Lawyers. He's done, ski chat. This is it. This is Euro Glanville's death ride.
The contempt is directed. Trial court has the power after conforming the contempt door to opportunity
Yes,
to
she has
speak in his
single
own
video.
behalf.
Yes.
Announce punishment
She's very well
summarily
endowed.
without
Very
further
good
notice
what
of
she
hearing.
does.
I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm going to disagree with you. Okay.
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them by nature.
Okay. Well,
you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also
but you got the information. But here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay. I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute, but I do believe that somebody did tell him what was the sum and substance of the court's conversations. And that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned
I
it.
think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt.
You're a
So
fucking idiot.
at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness.
Exactly.
You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that.
Oh, you bitch.
Anything else?
No, we'll file a
Gosney!
notice of appeal.
Okay.
We
Well,
have the
You
order reduced in writing.
Gosney!
I'm going to do that right now. I will say for the record at this point in time that Mr. Steele has in fact,
Yes, this case
or
all done.
has
No.
filed, and I will,
You ever seen a dumb fuck literally implode a case because his pussy got hurt? Here you go. He fucked around, he got in trouble, and he got mad. Case is done. This case is toast. It's done.
note this as part for the record. In this case,
This is it. Well, the prosecutors did it too.
he's filed a motion to set aside the contempt. He's filed a motion for a supersedious bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a supersedious bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
Just the case law on that is in Ray Hughes.
hold on.
Right.
The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that, in fact, I do one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of
It
law.
is, hold on. One second.
Wow. Wow.
It's Untema, it's a UNTEMA versus Smith, and that's 371 Georgia Appeals 19, which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's SYVERTSON. And that is 368 Georgia Appeals, Georgia App, I should say 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond.
I'm not going to grant him a supersedious.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies. Criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is, as long as he, when he tells me what the basis of the conversation was, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
And that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client.
Paramount.
So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk.
You can't violate confidentiality like this.
That is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt. And that is, you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person, because okay, I'm sorry.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out and we'll think about it.
Thank you.
Okay, all right. So we'll be in recess about 5 minutes.
Oh, we're taking a 5-minute break. We're taking a 5-minute break. I think someone, you smell that, chat? Smells like pussy in that courtroom, and it ain't coming from Ashley Merkant. We're taking a 5-minute break. Yeah, he's gonna go make a phone call. That's the thing though. This is an abuse of power, chat. This is truly, you like watching What the Hell's a judge is running amok. This is a judge running amok. Unchecked power. And his power is he's unmoored. It's a barge floating loose on the river about to plow into a bridge. His power is completely unmoored at this point. Stephen Cooper says, I don't think this judge knows what contempt is. I mean, he just doesn't like being told no. Revan is saying, is it not a practicing judge? No, he's actually got, like, Judge Glanville. Yeah, no, he's got an accomplished record. Yeah, okay. Well, actually, you wanted hear something funny, chat? He is the chief judge. So you guys were like, they should go to the boss judge. He is the boss judge. So he's been a judge since 2005. Since 2022 to present, he's the chief judge of the Atlanta Judicial Circuit. And from 1995 to 2004, he's a magistrate. He has his master's from the U.S. Army War College. His Juris Doctor is from the University of Georgia. He got his bachelor's in history from Georgia in 1984. He's a brigadier general in the United States Army Court of Criminal Appeals, which that's not easy to get onto. He was the commanding general in the NATO support of the Rule of Law / the support mission and the Rule of Law field group out in Afghanistan. So he was the leading attorney out there that was advising NATO on what the rules of war, the laws of armed conflict are, which those are pretty important. Geneva Convention compliance. So he's got experience. He was a senior trial prosecutor in the solicitor's office in DeKalb County. He was a senior prosecutor in the JAG Corps. He was a defense attorney. And this is the other side of the JAG Corps, the U.S. Army Trial Defense Service. So, I mean, he's done shit. He's not just a mope. And if he's a brigadier general, that's a career thing, which he probably did out of law school. That's a 30-year career there in the military. So, there you guys. You wanted to know about him. There you go. There you go. So, he's not a rum-dum. And I wouldn't call him a diversity hire. Earlier today, so yesterday, a guy in Young Thug's trial was testifying. And he said, fuck y'all, I ain't talking. He was given immunity, and he still said, fuck y'all, I ain't talking. So the judge held him in contempt and took him to jail. This morning, there was an ex parte communication, meaning a meeting between one side of the aisle, meaning the prosecutor, and the judge, which is already a no-no, and that witness and his defense attorney. And the defense was not invited to that meeting. And Brian Steele found out about that meeting, probably either through the attorney who was there representing his client, or the defendant or that guy himself got word out, the witness got word out that this happened. And the gist of that meeting was an allegation that depending on how well you testify, you get to go home today. Shocker, the guy went home today because he testified and complied. Brian Steele confronted Judge Glanville about that. And Judge Glanville's first words weren't, you're right, I was wrong about that. His first question was, who told you about that? Ex parte communications like this are a massive violation of the rules of ethics. Massive. More importantly, this witness had already been sworn in. Once a witness is sworn in on the stand, you can't communicate with them like that. No one's allowed to talk about any substantive matters. And they did. So this is a whole big mess of fuck the judge and the prosecutor created. And Brian Steele found out about it and called him out and said, this is bullshit. And Judge Glanville held him in contempt for not telling him what happened. And how did he find out? And that's where we are. Brian Steele was taken into the back. The judge said, fine, you're getting cuffed up. He had him taken to the back for about 15 minutes. And then had him brought back out because, Young Thug's missing his attorney. So the judge said, fine, I'll give you till the end of the day to tell me what happened. And Brian Steele is still not saying who did it. He's staying an OG. And all these attorneys showed up to defend him. So, yeah. That's how we are. Judge about to get felted. Not right now, but the Court of Appeals will felt his ass. This has been a very long 5 minutes. I know. Judge Glanville. Judge Glanville, where are you? What happens if the judge doesn't come back? That would be great. He just pulls a Homer Simpson. And he just walks out the door of the chambers. He walks into his chambers and he just opens a window and he's like, ah! And he runs out to his car and takes off. Oh, that would be good. That would be good. Oh my God. So there has been a motion filed, and we can take a look at that real quick. So this is a motion from the wife. Brian Steele's wife is also an attorney, and this was filed. Check out the time this thing got filed. 5/16. So it's a motion to set aside contempt. And they're trying to show that he's the counsel of record for Jeffrey Williams, also known as Young Thug. The jury trial commenced January 4th. It is ongoing. Okay, my bad. 88 days in, and we're at June 10th. So the court, along with the prosecutors, engaged in an ex parte hearing with the sworn witness for whom an order of immunity was issued. The witness had previously asserted his Fifth Amendment privilege and was held in contempt. The court and the state admitted the proceedings took place. The attorney for defendant Jeffrey Williams, Brian Steele, commenced proceedings in open court by disclosing the defense had knowledge of the information and demanded the same and proceeded to make a motion for mistrial. Okay. That's all good so far. You can do that. You totally can do that. There's nothing wrong here. And then it just snowballs from here, chat. And they are loading down for bear. The second part of this is the judge wanted to know how Steele came into possession of the information and expressed outrage he knew of it. And now we talked about this here with Rule 1.6. Confidentiality of information. That's the big one here, chat. That's the big one. All right. Comment 5 says here, this is the big thing. Rule 1.6 applies to matters not just communicating in confidence, but all information gained, whatever its source. A lawyer may not disclose such information except as authorized by the Georgia Rules of Professional Conduct or other law. So the judge can't force him absent an actual law or some obligation there, and there isn't one. Then we get the next page. And then, yes, that's the point that the court repeatedly demanded he reveal the source, claiming the information was unlawful. Well, it's not really. And Brian Steele declined to provide it. This information was never deemed to be confidential by a court order placed under seal or subject to a protective order like a gag order. So there was no gag order under seal, anything that would stop this from happening. Is the judge busy retaining Ty Beard? Yeah, he's trying to get a telephone notary done. The court held Steele in criminal contempt for refusing to provide the information. Based on information and belief, Mr. Steele will decline to disclose the information. Based. The court stated he could only purge the contempt by telling the court where he got information that he shouldn't have had. Well, that's not how that works, Judge. Thus, the court has imposed an illegal and inherently inconsistent punishment. That's some alliteration. Illegal and inherently inconsistent punishment for this criminal contempt. Moreover, the court, now notice, notice the court has been lowercased. That's a sign of disrespect. Because normally you type it, you reference the court you're in front of, it's capital C. So the judge, they go here to talk about how should this contempt be done. Where the announcement of punishment is delayed and where the contumacious contact was directed toward the judge, where the judge reacted to the conduct in such manner as to become involved in the controversy, the judge may give the attorney notice of specific charges but the hearing, including the attorney's opportunity to be heard, must be heard by another judge. We didn't have that today. He has not been afforded due process, including a right to notice and be heard. Yeah. And then they cite some case law here that an attorney may not be held in contempt for statements made during courtroom proceedings only after a court has found that the attorney's statements and attendant conduct interfered or imposed an imminent threat of interfering with justice. The attorney knew or should have known that the statements exceeded the outermost bounds of permissible advocacy. And then because contempt is a crime, the evidence must, of course, support these findings beyond a reasonable doubt. Yeah, I don't know if it's going to work. And they say to the extent this court believes contempt is civil, there must be a clear and unequivocal order of the court that Mr. Steele is deemed to violate that needs to be addressed. It certainly cannot be the law that every time a judge asks a question, the failure to answer lands you in jail, especially when counsel has a colorable basis for declining to answer the question, and he does. He does. He has an entirely reasonable basis for answering the question. And it was filed by Colette Resnick Steele. So good for her. Standing by her man. Also, chat, the judge is still not showing up. I think he ran off. Chat. There's also another motion that was filed, or another notice, and that was the notice of appeal. And that was filed a little earlier. They filed that at 4/24. So it's a notice of appeal saying that Georgia Court of Appeals, they're going to order of contempt by the criminal contempt. And they're going to ask for the transcripts of evidence of the proceedings be included. That includes the secret recording of the secret meeting that was had. So we're all going to find out what happened. Which is probably not good for the judge. The Court of Appeals has jurisdiction over this case, and it's June 10th. Colette Resnick Steele. So Steele's got his he's got his boo in there working this. Uh-oh. I see movement. Uh-oh. Calling it right now. Look at that face. Look at that face, chat. Look at that face. Look at that face. Bitch made. I'm sure he's going to release him right now and be like, you're all good. Calling it now, chat. Calling it now. And he's going to bail. Let's see.
All right, thank you, madam.
Buck broken, yup. That's not a good face.
Yeah.
For you, perhaps. For you. For you. Completely felted. I think so, chat.
That's what we're using.
I think he got felted. Judge pooped. Oh, he got some clarity there. Yeah. Yes, the file rises. The file rises. Yes, the felt is moving.
Sergeant Brown, is everybody present? Needs to be present? All right, thank you for your patience, councils. The court's had an opportunity to reflect and,
listen, he's reflecting. Let's go. He's reflecting on the ball sack on his face. Oh, he reflected like a bitch.
Mr. Steele, if I could ask you to take the podium, please, as well. Now stand next to your attorneys.
Uh-oh, he's going to give it up. He's going to give it up. Look at him. Look at him strolling up there.
Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time.
Susar.
What, spell your last name for us?
SUSOR. Sierra, Uniform, Sierra, Oscar.
You're a good man. Good man. Okay. All right. Okay. All right. Thank you, sir. Okay. Mr. Susar as well. All right, counsels, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you under, still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. And you may take whatever steps you and your counsel deem appropriate after that. Okay?
You little faggot. You little faggot.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass,
that is
you have my my support. I will talk with our sheriff and we may be able to make that work. Okay. If that should occur. Okay. All right. Okay. All right.
Uh-oh.
All right. Is Miss counsels, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss thank you, Miss Merchant and Mr. Susar.
Thank you.
Okay. All right.
Wow.
Yes, in fact, the clerk is going to file a copy. It's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there directly. Download from there.
Judge Merchant and I will file interest of appearance on behalf of Mr. Steele.
Sure, that would be great. Thank you so much. Okay. All right. All right, State, is there anything else we need to, or any defendants, is there anything else we need to take up before tomorrow morning? Mr. Copeland is going to rejoin us tomorrow morning, so we'll continue with his testimony. Where's Miss Bumpus?
Your Honor, I have a matter.
1 second. Where's Miss Bumpus? She hasn't been released yet.
I'm not certain, and Miss Hilton is attempting to determine her whereabouts.
Uh-oh. One of the DAs left. Uh-oh.
All right, you can call her Miss Hilton. Thank you.
Oh, no.
All right, Mr. Sharp, sir.
Oh, no.
Your Honor, I have to prepare for my cross-examination of Kenneth Copeland over the next few evenings. And I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time, respectfully. Okay?
You can't do that.
Your Honor,
that's
respectfully,
error.
and
that's not
if it's
legal.
not released by the time that we cross-examine Mr. Copeland, our
you can't
our
do
defense will be hindered. in that
Sure, that will be an issue you can certainly raise then and that now, but I'll think about it. But at this point, I'm not inclined to release the transcript of the court's ex parte hearing because of the way it was the way it was disseminated. That's why I'm not inclined to do it.
And I would also, I understand the court's ruling. I would also ask for the release of any audio tapes regarding that hearing as well.
Well, the only audio tape that I know of is maintained by Miss Weaver, who tapes her proceedings in order for her to prepare a transcript. So,
100% and elite. Well,
okay. Well, I don't know if she may not have any, but we'll see. Okay.
Your Honor, good evening. Carson Matthews on behalf of Mr. Cooley. We were making that same request, Your Honor, for that transfer. We potentially could contain some grading material.
Sure. Okay. All right. Unless there's anything else, counsel?
tell him to recuse. Tell him to recuse.
I join that, and I also believe I advise the court the reason that I also want for confrontation cross-examination is supposed admissions.
We're live right
Mr.
now.
made
Live.
about our case outside our presence, and based upon information and belief, the court handed Mr. Copeland allegedly the long false swearing and perjury. And if that's true, I'd like to also talk with him, if he'll talk, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information.
Madam.
Your Honor, there was no matter to which
you are now a witness. You are now a witness, prosecutor. They have the right to cross-examine you now.
either counsel for either of the defendants was a party. There was no matter to which either defendant in this case was a party that was had or held outside this courtroom. So
this right here are two witnesses, W1 and W2, talking to each other about something they both saw and experienced and engaged in. This should not be happening. I'd almost stand up and say, she can't talk to you because she's a witness. Witnesses aren't allowed to confer like this. This is problematic. Seriously, and like I said, I'd like to think I'm saying all the things Ashley. I hope Ashley Merkin and all them are wanting to say all this shit. But hopefully I don't sound like a retard out there, chat. I don't know. I'm trying not to.
we would ask that the court deny what is being requested of the court, because that is something to which neither defendant is entitled.
Entitled.
Is on the witness stand. The witness is on the witness stand. The witness is testifying under the RICO Act, which covers all of the defendants. It's understanding upon information belief that particular witness has stated again on Friday that he was not going to testify. That today it was a different scenario, and based upon it, we believe that we should be entitled to that on the Brady, because we believe it's potential Brady material.
All right, sure.
And it's covered under the RICO statute. He's testifying against all of these defendants under RICO. So we all are part of this witness's testimony.
Your Honor, I would additionally point out that the question to which Mr. Copeland asserted a Fifth Amendment privilege was, how old are you?
On Friday.
Yes.
Yeah. All right. I'm going to deny your motion, Mr. At this time, Mr.
It doesn't matter because you guys talked about shit behind closed doors. God knows what you talked about. The allegations are you talked about if you testify, you'll go home. And then also apparently the judge handed him a document relating to the state law and perjury. Well, we have a right to see all of that. That's all Brady material. It's all exculpatory. It all leads to bias that he was motivated to testify so he could go home. These guys are asking the right questions. They all need to keep beating the drum right now.
Matthews.
Your Honor, I don't understand the state's argument that we are not a party. This gentleman was sworn in as a witness against all of our clients. He is sworn in as a witness specifically against Mr. Stillwell.
Exactly.
Conversations with that gentleman were occurring apparently ex parte without our knowledge, without my client's presence. And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients. We are certainly a party.
Okay.
And we were denied the right to be present.
All right. Thank you, sir. I'm still going to deny it. All right. Anything else?
We would ask for a copy of that transcript since it's germane to the contempt. So we will be asking for that in the court order as soon as this court order, since that is.
It's an ex parte matter, so you're not going to get it unless the appellate court wants to see it, if it's accepted. So, but I'm not going to give it to you at this point in time.
I assume the Harvey rule applies.
Yes, sir.
Thank you.
All right. All right. See y'all tomorrow morning, okay? 9:30 for an anticipated 10 o'clock start time? Okay, we're recessed.
Wow. Wow, chat. Wow. Crazy shit, man. Here's the thing. He didn't triple down. He gave him till the weekend to start the sentence. That gives him time to kind of wipe his hands of it and let the appellate court take it away from him. That's a bitch out. He bitched out, but he did it like on the down low. He slinked away on his own. Did the prosecutor agree this knowing a mistrial is possible, Sven? Throw the case? Well, if they agreed to this, it's prosecutorial misconduct to have an ex parte communication with once that witness is sworn in, and on Friday he was sworn in, you're not allowed to speak to witnesses. So they engage in prosecutorial misconduct intentionally, then that's a mistrial with prejudice and a dismissal with prejudice. So that was fucking disgusting. That was actually a travesty of justice that you guys got to see there. I'm fucking embarrassed. I'm embarrassed that man's an attorney. That man went to law school and he just did that. That is fucking embarrassing. AK says, can the prosecutor be in trouble? 100%. She could get sanctioned for this, but yeah, but like Fanny's not going to fire her. This is Fannie Willis's team. And then Ghost says the appellate court has the appeal. It was filed. And then the appellate court, here's the thing, kind of like what happened in the Richard Allen case where the judge had that secret transcript she wouldn't release. The appellate courts can demand that, and you will provide it. And they've asked for the transcript, and the appellate court's going to be like, yeah, we should see what happened. And they're going to demand it. And that judge can't tell him to fuck off. The appellate court's going to throw this out. He'll be fine. He will not set a foot. I could see Brian Steele wanting to set a weekend in the jail just as solidarity for his client, because those guys have been in jail for almost a year and a half now. I could see him still wanting to go, but the Court of Appeals is going to go too fast on ruling on this. Mr. Potato said, would the RICO case be retried? Or would it be considered double jeopardy since they fucked themselves? Oh, this is done. There's no way you can redo this trial. It's a disaster. Do you think the judge will get sanctioned? Oh yeah, he's not walking away from this one. This was disgusting. This was an embarrassment. The Court of Appeal, the courts and the governing bodies will punish him appropriately. Well, don't call it a comeback. He's been here for years, chat.
Boy, in and out, man. Hey, I don't hope I'm not interrupting anything, but.
Did you hear what happened?
So the judge held him in contempt, says he's got to report on the weekends.
That was his way of trying to skid her out from underneath this, I think.
Yeah, so basically he's expecting for the appellate courts to bail him out.
Well, and yet the thing is, though, it's too late. Though, even though that happens, it's
Well, and then then the one lawyer I watched back, I was watching a replay just before I signed on your channel, and that is that then the other lawyer says, "Well, are you going to release the transcript?"
Yeah.
And
Once again, he
like,
said nope.
And then the appeal, the interlocutory appeal on the thing says, it's part of the appellate record, so we want it as part of the appeal.
And the appellate court's going to demand it, and he says he'll provide it. So I guess we'll get to see it at some point.
It's a disaster. This
trial's done. This trial's done.
It's a mistrial. It's obviously
mistrial with prejudice. This is an 18 months in the making. These guys have been sitting in jail for 18 months now. Over a year and a half they've been waiting.
This is interesting because double jeopardy bars retrial when you have prosecutorial misconduct.
I'd argue the prosecutor willingly went along with this.
I don't know. It's a harder argument though because it's a judge created error.
Well, no, the prosecutor created error too, though, by willingly doing I think they both had their hands in it.
And then, of course,
because
now you've
the
got
prosecutor, it sounds like part of the argument is.
See, when you screw up royally, all the issues start flying, and there's another issue of that is denial of counsel. Because it's like, well, you can be sitting there in court, but you aren't going to be able to research over the weekends. You get all your best stuff done on the weekend.
Mm-hmm. Yeah. Well, I think it's funny where he said, if you're going to send me to jail, I want to hang out with my client.
Yeah.
That was so cool.
That was cool.
That was such a smart ass comment.
The defense bench is pretty good over here.
Well, the defense bench, both all those attorneys started fighting. But that's the thing, like the Trump team, like the team in the Trump case, and then these guys, these are like the best attorneys in the city, it looks like, from what I can tell.
How did the bench get? I mean, this guy is just a disaster.
I think he kind of got a little in under. Like, I think any judge would have gotten over their head on this one.
I don't know. I've been in some great judges, and
I know, but I think he he's got a decent background. Well, he's a career, he's made his way through the JAG Corps all the way up. I mean,
see what people don't realize about
he's not a schmo. But no, I think Judge Glanville. I think he kind of got out over he got a little into it too deep, and then he didn't know how to get out.
Yes,
so
and he looks to me like he's relying on a lot of Westlaw head notes.
Yeah, and he got stuck in there. He got called out, and he's like, "Oh shit!" But this is, and this is kind of one of those things. Like anybody will do this. When you get cornered, you start fighting.
Yep.
And you keep digging in, and
he
just kept digging and digging and digging.
That's why humility. I think I've told the story before that Clarence Thomas was. I've spoken to him a couple times, and he says humility is one of the greatest qualities in a judge. Mm-hmm. And this guy doesn't have any of it. He's rolling over people. He's an arrogant a-hole.
Yeah, and he's been, and I understand you guys are saying I'm giving him too much credit for his background. Okay, I get it, but my point is he wasn't just some rum-dum ambulance chaser, or he wasn't some guy who just schlepped his way through the prosecutor's office for whatever amount of time. He had to display a little bit of ability to do his job. Expect a guy with these kind of credentials to fuck up this bad.
Well, I guess when you get the more degrees you get, the more you realize it doesn't mean anything.
Oh yeah, you know what you don't know. Yeah. I'm just a little disappointed that this guy did this.
I'm very disappointed. This is a very disappointing performance, and it's bad for law. See, this is what people do. It's not about this guy or this trial necessarily. Mm-hmm. This is when you have this kind of incompetence, it's bad for the law. It's bad for the state, and law is essential for an operating society.
This is seen all over the country and all over the world. This makes it a mockery. And we can make all the jokes, ha ha ha. Hee hawville, Georgia. This is going down.
It's not. It's Atlanta. It's a big city.
That's what I mean. But I'm just saying, people can go, ha ha, they're hillbillies in Georgia. This is embarrassing to me as a guy who went to law school, that people are like, wait, this is what people from law school do? Someone who's an attorney can do this?
Yeah.